say goodbye to our learned brother in 2 days. So, because the Constitution tells us when the time has come. So we were just in a group photograph and other things with the staff and other things. So there are 4 judgments in all. In this case, there's a judgment by me. There's a judgment by Justice Kaul. There's a judgment by Justice Narasimha. By Justice Bhatt, and there's a judgment by Justice Narasimha. So, consistent with the importance of the case, I'll begin by reading out some of our portions. There's a degree of agreement and there's a degree of disagreement on how far one has to go. As I see, the degree of disagreement is on how far we have to go. But I'll read out my judgment. Then I'll request Justice Kaul to, I shouldn't say I'll read out my judgment. I'll read out parts of the judgment which are relevant. Abdel? Briefly refer to some of those extracts. The doctrine of separation of powers, as it is traditionally understood, means that each of the 3 organs of the state perform distinct functions in distinct spheres. No branch performs the function of any other branch. Actually, Mr. Sibal, Mr. Solicitor, all of you can take a seat. I mean, you don't have to stand to receive the judgment. It will take a little time, so you can all be seated for a bit.
Objection.
The traditional understanding of this doctrine, also termed the pure doctrine, does not animate the functioning of most modern democracies. That our constitution does not reflect a rigid understanding of this doctrine has long been acknowledged by the court. In practice, a functional and nuanced version of this doctrine operates, where the essential functions of one arm of the state are not taken over by another arm, and institutional comity guides the actions of each arm. In other words, the functional understanding of the separation of powers demands that no arm of the state reigns supreme over another. The Union of India suggested that this court would be violating the doctrine of separation of powers if it determines the list in this case. The separation of powers undoubtedly forms a part of the basic structure of the Constitution, but equally the power of courts to conduct judicial review is also a basic feature of the Constitution. The doctrine of separation of powers certainly does not operate as a bar against judicial review. In fact, judicial review promotes the separation of powers by seeing to it that no organ acts in excess of its constitutional mandate. It ensures that each organ acts within the bounds of its remit. Further, as discussed in the previous segment of this judgment, the Constitution demands that this court conduct judicial review and enforce the fundamental rights of the people. The framers of our Constitution were no doubt conscious of this doctrine when they provided for the power of judicial review. Being aware of its existence and what it postulates, they chose to adopt Article 32, which vests this court with broad powers. The doctrine of separation of powers cannot therefore stand in the way of this court issuing directions, orders, or writs for the enforcement of fundamental rights. The directions, orders, or writs issued for this purpose cannot encroach upon the domain of the legislature. This court cannot make law. This court cannot make law. It can only interpret it and give effect to it. Page 73 पर एक correction है. Then I'm dealing with now in another segment of the judgment, which is titled "Queerness is not urban or elite." The discussion in this segment has not scratched the surface of the rich history of the lives of LGBTQ persons in India, which continue into the present. Yet even the limited exploration of the literature and reportage on the subject makes it abundantly clear that homosexuality or queerness is not solely an urban concept, nor is it restricted to the upper classes or privileged communities. The discussion in the preceding paragraphs reveals the diversity of the queer population. People may be queer regardless of whether they are from villages, small towns, or semi-urban and urban spaces. Similarly, they may be queer regardless of their caste and economic location. It is not just the English-speaking man with a white-collar job who lives in a metropolitan city and is otherwise affluent who can lay claim to being queer, but also and equally the woman who works in a farm in an agricultural community. Persons may or may not identify with the labels queer, gay, lesbian, trans, etc., either because they speak languages which are not English or for other reasons. But the fact remains that many Indians are gender queer or enter into relationships with others of the same sex. In the words of a person assigned female at birth who worked at a factory in Ajmer, and I've quoted the To imagine queer persons as existing only in urban and affluent spaces is to erase them, even as they exist in other parts of the country. It would also be a mistake to conflate the urban with the elite. This renders invisible large segments of the population who live in urban spaces but are poor or otherwise marginalized. Urban centers are themselves geographically and socially divided along the lines of class, religion, and caste, and not all those who live in cities can be termed elite merely by virtue of their residence in cities. This walk through history is not an attempt by this court to take on the mantle of historians. The discussion demonstrates that the institution of marriage has not remained static or stagnant. To the contrary, it is change which characterizes the institution. All social institutions transmogrify with time, and marriage is no exception. From sati and widow remarriage to child marriage and intercaste or interfaith marriages, marriage has metamorphosed. The institution as we know it today would perhaps be unrecognizable to our ancestors from 200 years ago. Despite vehement opposition to any departure from practice, the institution of marriage has changed. This is an incontrovertible truth. Here it is also important to take note of the fact that these changes were brought about largely by acts of parliament or the legislatures of the states. While the passage of many laws was preceded by significant social activism, it was the legislature which ultimately responded to the call for change. Even as parliament and in some cases the courts expand the liberties of the people to conduct their lives in a manner they see fit in accordance with law, many sections of society remain opposed to these changes. Regardless of such opposition, the institution of marriage has undergone a sea change. It is therefore incorrect to characterize marriage as a static, stagnant, or unchanging institution.